Well, we're now joined by the Alberta Premier Danielle Smith. Premier, thank you for joining us again.
You bet, my pleasure.
Now, since Friday's decision, many articles have been written about what the ruling actually means for the federal government's Impact Assessment Act. I'm wondering what you take out of what you heard from the top court.
What I take out of it is that the federal government has been acting in an unconstitutional way. They passed this legislation 6 years ago and created a lot of investor uncertainty. And the Supreme Court sided with us, as well as several other provinces who intervened with us, business groups and First Nations, in saying that the Constitution matters. That you, in a system like we have, which is cooperative federalism, you have to underscore the first word, cooperative, and they haven't been. They've been acting in a unilateral way, and the Supreme Court reined them in. I'm glad of it. So now I'm hoping that we can get to the table and we can actually talk about a truly collaborative way that we can meet our shared goals.
Well, it's interesting because, Jonathan Wilkinson, in his reaction to the Supreme Court ruling on the Friday, he did say, Canadians are better served when people work together rather than going through the court. So do you think that's a change in tone? Do you think that's something that has any resonance outside of Ottawa?
Well, I hope it is the case, because the problem that we've seen is that the federal government keeps on passing what we perceive as unconstitutional laws. And then they make us go through the expense and the time and the effort to try to prove that they're wrong. I guess if they want to avoid going to court, then they should stop passing unconstitutional laws. They should stay within their own jurisdiction. And if they do want to legislate in an area that has an impact on us, talk to us and let's see if we can find some kind of solution. Because this isn't the only area. Remember, they also want to bring through an emissions cap on oil and natural gas. They talked about an emissions cap on fertilizer. They talked about having an emissions cap on methane. They want to bring through clean electricity regs. Electricity is clearly in our provincial jurisdiction. They want net zero houses. They want also as well to have a ban on the sale of combustion engine vehicles. Like they have been putting these kinds of aggressive policies out unilaterally without consultation for the last number of years. And I hope that they heard what the Supreme Court said, which is stop doing that and start working with the provinces so that you are staying within your own boundaries, your own lane.
Okay, so it's interesting that you raised the electricity regulations because, of course, you are in the midst of a campaign against Ottawa's net zero electricity grid by 2035 when it comes to Alberta. And, the Minister Guilbeault's office did send us a statement, and this is in regards to Friday's ruling as well as those electricity regulations. Take a listen to what we heard from the office. They said, the opinion of the court does not call into question other regulatory initiatives under development, and we are confident that we are within the purview of the federal government, for example, the clean electricity regulations. Of course, we know how important it is to get all regulations right and will continue to come to the table in good faith to consult with the provinces. Notwithstanding some of the rhetoric Canadians may hear, those consultations have been going very well. What's your reaction to that?
Well, I can tell you that they have not been collaborative. They have not listened to what we've told them. But I told them right from the beginning, before they even came out with these regulations, because I knew where they were heading. I said, it won't work for Alberta. It won't work for our industry. Work with us on aligning to a 2050 target. And they decided to go ahead with it anyway. And so that is not the spirit of cooperative federalism. And I think Minister Guilbeault should read the Constitution, because under Section 92, it says quite clearly that electricity is the exclusive jurisdiction of the provinces. And so this is the frustration that I have, is that the words don't match the actions. And so if they genuinely want to talk with us, we have a table set up. I've got deputy ministers who are going to be in Ottawa this week, meeting with their counterparts, and we'll see if the tone has changed, because I think we can work together towards a 2050 target. But I remain firm that 2035, the way that they have unilaterally attempted to impose it, is not achievable in Alberta. We are not going to put our electricity grid at risk from a reliability point of view, and we are not going to put our customers at risk from an affordability point of view. We want to be able to achieve all of these things together.
Okay, so that's the electricity regulations. Let's get back to the Impact Assessment Act, because as you know, both Minister Guilbeault and the Natural Resources Minister think that they can still keep the regulations alive. They point out that the court did not strike down the law. They essentially just gave advice on it. So with some amendments, they believe the act can stand if it stays closer to what's deemed to be federal responsibilities. If that's what they're saying, what do you hope comes out of those types of amendments? Do you hope they amend it or start all over again?
Well, it would be nice if they scrapped it completely and started all over again, building it on the right premise. But I suspect, based on what I've seen, that they're not intending to do that. But it's pretty clear to me that the court said if it's on federal lands and it's federally funded, or it's a federal project outside of Canada that they're funding, then they have jurisdiction. But when it's in provincial jurisdiction, 100% within our boundaries, and they aren't funding it at all, they don't have a say. These are things that the Constitution clearly defines. Natural resource projects, as well as electricity projects, are the purview of the province. So I recognize that we have to work together on emissions reduction. I've been putting out my hand to do that ever since I first got elected, with my first conversation with the Prime Minister saying let's align around 2050. And we're going to continue doing that. But they have to stop acting as if they have carte blanche to unilaterally pass policy without consulting with the people who are going to be impacted. And I hope that they got that message from the Supreme Court, because that was the message that the Supreme Court sent.
So what do you say, though, because they point out to things like waterways, endangered species, indigenous communities, those things do fall under federal purview, and they will, even if it's in a province and under that regulation, there will have to be some negotiation. What do you say to that?
Oh, and we are happy to negotiate with them, but they can't use that as a pretext. The court very clearly said that you cannot do indirectly what the Constitution forbids you from doing directly. So I don't want the federal government to be cute and to be trying to use some other way to be able to stymie our projects. I think what needs to happen is they need to look at what the genuine environmental concerns are, always, as we have historically, and then let's work to mitigate them. That I think is a legitimate approach, and there's a role for cooperative federalism in that. But that's not how they've been behaving. They've been behaving in a unilateral way, and they got called out on it. It's not legal, and they should stop doing it.
Premier Danielle Smith, always appreciate the time. Thank you for that.
You bet, my pleasure. Talk to you again.